I was pouring my second cup of coffee when I saw the woman marching across my lawn like she owned the place, a clipboard clutched against her chest, and her lips pressed into a tight line that screamed trouble. My name is Xenakis, and I had dealt with enough bureaucratic nonsense in my 20-year career as a senior legislative analyst for the state of Arizona to recognize someone who thought they had power long before they opened their mouth. She rapped on my door with the kind of aggressive knocking that suggested she had been practicing. I opened it with my coffee still in hand, and she immediately thrust a piece of paper toward my face. "Mr. Xenakis, I am Patricia Henderson, president of the Saguaro Heights Homeowners Association. I am here to inform you of multiple violations you have committed against our community standards." Her voice had that particular nasal quality that came from years of complaining about everything from lawn height to paint colors. I took a sip of my coffee and glanced at the paper. "And good morning to you too, Patricia." Her eyes narrowed. "This is a serious matter. You have 14 days to correct these violations or face fines of $500 per day." I scanned the document while she stood there, clearly expecting me to grovel or argue. The list was impressive in its petness. My hedge was supposedly 2 inches too tall according to community standards. My mailbox was the wrong shade of black. I had placed a small decorative fountain in my front yard without HOA approval. And apparently my garage door had been left open for more than 4 hours on 3 separate occasions. "These regulations," I said slowly, looking up at her, "where exactly did you get them?" "They are in the HOA bylaws, section 12, subsections A through G. Every homeowner received a copy when they purchased their property." She said this with the confidence of someone who had never been challenged. "Right. And these bylaws reference Arizona Revised Statutes Section 33, Chapter 16, correct?" Her confidence wavered slightly. "I do not need to discuss the legal foundations with you. You simply need to comply." I smiled. "Patricia, you know what I did before I retired last year. That is irrelevant to. I was the senior legislative analyst for the Arizona State Legislature's Housing and Property Committee." "Do you know what that means?" Her face was beginning to turn an interesting shade of red. "Mr. Xenakis, your career has nothing to do with. It means I wrote the regulations you're trying to cite." I tapped the paper with my finger. "In fact, I spent 3 years drafting and revising Arizona Revised Statutes Section 33, Chapter 16. The very chapter your HOA bylaws claim to be following." The color drained from her face, then returned twice as bright. "That doesn't give you the right to ignore our community standards. Actually, Patricia, let me show you something." I pulled out my phone and opened my photos. I had kept digital copies of everything from my legislative work. "This is the original draft of Section 33-16-42. You see this language here. No homeowners association may enforce aesthetic standards that exceed reasonable community expectations or impose punitive fines without first providing detailed documentation of how said standards protect property values." She snatched the phone from my hand, squinting at the screen. "This is just a draft. It doesn't. That language made it into the final version, which was signed into law in January of 2023. Your bylaws were updated in March of 2023, which means they fall under these regulations. Now, let me see that violation notice again." I took the paper back and read through it more carefully. "You are citing me for a hedge that is 2 inches too tall. The statute requires you to demonstrate how those 2 inches materially affect property values or community safety. You are citing me for a mailbox shade. The statute explicitly states that HOAs cannot enforce color standards unless the color in question is deemed offensive or deteriorating, neither of which applies to a well-maintained black mailbox. Shall I continue? Patricia's mouth opened and closed like a fish. We have the authority to maintain standards in this community. The board voted on these regulations. The board doesn't have the authority to supersede state law. And Patricia, there is something else in Section 33-16-57 that you should know about. It states that HOA board members can be held personally liable for harassment if they knowingly enforce regulations that violate state statute. Harassment. I am doing my job. Your job is to follow the law. Tell me, did your board consult with an attorney when they drafted these bylaws? Her silence was answer enough. Let me guess. Someone found a template online, maybe from an HOA in another state, and you all voted to adopt it without actually checking if it was legal in Arizona. We have every right to maintain property standards, within the bounds of state law, yes. But what you have handed me violates at least 6 different provisions of Arizona state statute. I can list them if you would like. I pulled out a pen and started writing on the back of her violation notice. Section 33-16-42, failure to provide evidence of material impact. Section 33-16-47, excessive fines without graduated enforcement. Section 33-16-51, enforcement of aesthetic standards that exceed state maximums. Section 33-16-53, failure to provide adequate notice and appeal process. Section 33-16-55, discriminatory enforcement. And Section 33-16-62, harassment of homeowners through frivolous complaints. Patricia stared at the list I had written. This is ridiculous. We have maintained these standards for years. That doesn't make them legal. In fact, it makes the liability worse because it shows a pattern of violations. I handed her back the paper. Here is what is going to happen, Patricia. You are going to go back to your board and tell them that you need to consult with an attorney who actually specializes in Arizona HOA law. You are going to review every single one of your bylaws against current state statute, and you are going to rescind this violation notice. And if we don't, then I will file a complaint with the Arizona Department of Real Estate, which oversees HOA compliance. I will also file a lawsuit against the HOA and personally against every board member for harassment and violation of state statute. Given my background, I can assure you that I know exactly how to make that complaint extremely detailed and effective. She turned on her heel and stormed off my porch, but not before I saw the uncertainty in her eyes. She had expected compliance or maybe argument, not someone who knew the law better than she did. I closed the door and finished my coffee. Part of me had hoped that retirement would mean less dealing with bureaucratic stupidity, but apparently, the universe had other plans. 3 days later, I received a certified letter from the HOA. It was not an apology or a rescission of the violation notice. Instead, it was a formal hearing notice, informing me that the HOA board would be meeting to discuss my violations, and that I was required to attend if I wished to contest the findings. Required. As if they had the authority to require anything from me. I marked the date on my calendar and spent the next week doing what I did best: research. I pulled up every single one of Saguaro Heights HOA's bylaws and compared them against Arizona state statute. What I found was worse than I had expected. The bylaws were a mess of outdated provisions, illegal requirements, and procedures that directly violated homeowner rights. They had a clause that allowed them to enter properties without notice for inspections. that violated Section 33-16-44, which required 48 hours written notice except in emergencies. They had a provision that prohibited political signs during election seasons. That violated First Amendment protections that were specifically reinforced in Section 33-16-39. They had fine structures that started at $500 for first violations. State law required graduated enforcement starting with warnings. I compiled a 40-page analysis of every violation, complete with citations, case law, and references to the legislative intent behind each statute. If they wanted a hearing, I would give them a hearing they would never forget. The meeting was held in the community center, a bland stucco building at the edge of the development. I arrived 15 minutes early with a briefcase full of documents. The room was set up like a small courtroom, with a table for the board at the front and chairs arranged in rows for residents. About 20 people were scattered throughout the room, most of them looking bored or annoyed at having to be there. Patricia sat at the center of the board table, flanked by 4 other board members. 2 men and 2 women, all middle-aged, all wearing expressions that suggested they took their volunteer positions far too seriously. This hearing of the Saguaro Heights HOA board is now in session, Patricia announced, banging a gavel that seemed unnecessarily theatrical. We are here to address violations committed by Lucas Xenakis of 4782 Desert Willow Drive. Mr. Xenakis, you have been provided with the list of violations. Do you wish to respond? I stood up and walked to the front of the room. I do. But first, I have a procedural question. Have any of you consulted with an attorney regarding the legality of these proceedings? One of the men on the board, a heavy-set guy with a comb-over, leaned forward. We don't need an attorney to enforce our own bylaws. That's interesting, because according to Arizona Revised Statutes Section 33-16-56, any HOA hearing that may result in fines exceeding $1,000 requires either the presence of legal counsel or a clear written advisement that homeowners have the right to bring legal representation. I see no such advisement in your hearing notice. Patricia waved her hand dismissively. This is just a formality. We are trying to maintain community standards. A formality that could result in fines of $500 per day, which would exceed $1,000 in 3 days. That makes this a material hearing under state law. I pulled out a document from my briefcase. I have prepared a formal objection to these proceedings on procedural grounds. Would you like me to read it into the record, or shall we skip to the part where you acknowledge that these bylaws are illegal? The board members exchanged glances. One of the women, a thin brunette with glasses, spoke up. Mr. Xenakis, we are all volunteers here. We are just trying to maintain property values. I understand that, but good intentions don't override state law. Let me walk you through exactly why these violations you have cited are unenforceable. I opened my briefcase and pulled out my analysis. Let's start with the hedge. You claim it is 2 inches too tall. Your bylaws state that hedges cannot exceed 42 inches in height. Arizona Revised Statutes, Section 33-16-42 subsection D, states that HOAs may not enforce height restrictions on landscaping that falls within reasonable community standards, unless they can demonstrate a safety concern or significant impact on neighboring property values. A 2-inch difference on a 42-inch hedge is neither a safety concern nor something that would impact property values. Therefore, this violation is unenforceable. We have the measurements, Patricia insisted. Your hedge is 44 inches. I'm not disputing your measurement. I am explaining that your bylaw itself violates state statute. The height restriction you have set is arbitrary and not supported by any legitimate community interest. In fact, when I drafted the language for Section 33-16-42, we specifically included protections against exactly this kind of overreach. The heavyset board member crossed his arms. So you think you know better than the entire board because you worked for the state? I think I know the law because I wrote it. Now, let's move on to the mailbox. You claim it is the wrong shade of black. Your bylaws require that all mailboxes be painted in approved colors from a specific list. The shade of black you require is Sherwin-Williams iron ore. My mailbox is painted in Benjamin Moore black. Both are standard black colors used on thousands of mailboxes throughout Arizona. Section 33-16-42 subsection G prohibits HOAs from requiring specific brand names or proprietary products, unless they are providing those products at no cost to homeowners. By requiring a specific Sherwin-Williams color, you are essentially requiring homeowners to purchase a specific brand, which violates state law. The brunette with glasses was writing notes frantically. We didn't know that was illegal. That is why you should have consulted with an attorney. Let's continue. The decorative fountain. Your bylaws require prior approval for any landscaping changes. However, Section 33-16-48 states that HOAs must approve or deny requests within 30 days of submission, and that delays beyond 30 days constitute automatic approval. I submitted my request for the fountain on January 15th. It is now March 3rd. That is 47 days. Under state law, my fountain has been automatically approved due to your failure to respond within the statutory period. Patricia's face was now bright red. We never received a request from you. I pulled out another document. This is a certified mail receipt showing that I sent the request to the HOA management address listed in your bylaws on January 15th. This is the tracking information showing it was delivered on January 17th. This is a copy of the request itself, which includes photos and specifications of the fountain. You received it. You simply failed to respond. The room was silent except for the scratching of the brunette's pen. Finally, the garage door violations. Your bylaws state that garage doors cannot remain open for more than 4 hours unless active loading or unloading is occurring. This provision violates Section 33-16-43, which states that HOAs cannot regulate the interior or functional use of private property. A garage is considered part of the private interior space of a home. Whether my garage door is open or closed has no impact on property values, does not create a safety hazard, and is not a legitimate concern of the HOA. The fourth board member, a man who hadn't spoken yet, raised his hand. But open garage doors look unsightly. They make the neighborhood look messy. That is a subjective aesthetic opinion, not a legitimate basis for regulation under Arizona law. The state legislature specifically included protections against this kind of aesthetic overreach because we recognized that HOAs were using subjective standards to harass homeowners. I paused and looked at each board member in turn. The reality is that your entire set of bylaws needs to be reviewed and revised. You are enforcing regulations that violate state law, which exposes both the HOA and each of you personally to significant legal liability. Patricia stood up, her hands gripping the edge of the table. We have authority granted to us by the homeowners of this community. We were elected to maintain standards. You have authority granted by state law, which is the supreme authority in this matter. Your election by homeowners does not give you the power to violate state statute. In fact, Section 33-16-57 makes it clear that board members can be held personally liable for knowing violations of homeowner rights. Once you have been informed that your bylaws violate state law, continuing to enforce them constitutes a knowing violation. The heavy-set man was sweating now. Are you threatening us? I am informing you of the law. What you do with that information is up to you. But if you proceed with these violations, I will file complaints with the Arizona Department of Real Estate and pursue legal action. And given my background and expertise, I can guarantee that those complaints will be taken very seriously. The board members huddled together, whispering urgently. Patricia kept shaking her head, but the others looked increasingly nervous. After several minutes, the brunette with glasses spoke up. Mr. Xenakis, could you give us a week to review what you have presented? We would like to consult with an attorney before proceeding. That's a reasonable request. I would ask that you provide written confirmation that enforcement of these violations is suspended pending your legal review. She nodded and started writing. Patricia looked like she wanted to argue, but the other board members were clearly ready to retreat. The brunette handed me a piece of paper stating that all pending violations against my property were suspended for 14 days pending legal consultation. I took the paper and headed for the door. As I left, I heard Patricia's voice rising in anger, but the other board members were shutting her down. It seemed that the reality of personal liability had finally penetrated their volunteer enthusiasm. 2 weeks later, I received another letter from the HOA. This one was from an attorney at a Phoenix law firm specializing in HOA law. The letter was polite and professional, acknowledging that the HOA's bylaws contained provisions that may not comply with current Arizona state statutes. They requested a meeting to discuss the matter and potential revisions to the bylaws. I agreed to the meeting, which was held at the law firm's office in downtown Phoenix. The attorney was a woman in her 30s named Jennifer Morrison, and she had clearly done her homework. She had a copy of my 40-page analysis in front of her, along with her own research. Mr. Xenakis, I have to say, your analysis is extremely thorough, more thorough than most of what I see from attorneys, let alone from homeowners. I spent 20 years writing this stuff. I know how it works, she smiled. The HOA board has asked me to help them revise their bylaws to bring them into compliance with state law. Given your expertise, would you be willing to consult on that process? We could compensate you for your time. I appreciate the offer, but I am retired for a reason. However, I can provide you with the framework for what needs to change. The key is understanding the legislative intent behind these statutes. They were designed to prevent exactly the kind of overreach that your clients have been engaging in. I understand that. But between you and me, this HOA is not unique. I have a dozen clients with similar problems. The issue is that many HOA boards are volunteers who have no legal training, and they rely on templates and advice from other HOAs without understanding the actual legal requirements. That is the problem we were trying to solve when we drafted these statutes. HOAs serve a legitimate purpose in maintaining community standards, but they need to operate within reasonable bounds. Too many boards see themselves as mini-governments with unlimited authority. Jennifer nodded. I have already advised the board that they need to rescind your violations entirely and issue a formal apology. They have also agreed to suspend enforcement of several provisions in the bylaws until we can revise them. What about Patricia Henderson? Jennifer's expression became carefully neutral. Miss Henderson has been asked to step down as board president. She will remain on the board, but the other members felt that new leadership was needed. I suspected there was more to that story, but I didn't press. Good. She was the primary driver of this harassment. Actually, Mr. Xenakis, there is another matter I need to discuss with you. Jennifer pulled out a different folder. In reviewing the HOA's records, I found a pattern of enforcement that raises some concerns. Over the past 2 years, your property has received significantly more violation notices than any other property in the community. In fact, you have received 15 notices in 2 years, while the average homeowner has received 2. 15. I only received the 1 notice from Patricia. The others were sent to your address, but according to the records, many of them were marked as resolved before you responded. It appears that someone may have been filing complaints against your property and then withdrawing them before they reached the formal violation stage. I felt anger building in my chest. Patricia. I cannot confirm that, but the pattern is concerning. Under Section 33-16-55, discriminatory or targeted enforcement can constitute harassment. If you wanted to pursue a complaint against Miss Henderson personally, you would have a strong case. I thought about it for a moment. Patricia had made my retirement more stressful than it needed to be, and she had clearly been targeting me for reasons I didn't fully understand. But I also knew that pursuing personal complaints would drag the process out and create more conflict. Not right now, but I want those records preserved in case I change my mind. Already done. I have advised the board that all enforcement records need to be maintained, and that any destruction of records could constitute obstruction. We spent another hour going through the specific provisions of the bylaws that needed to be changed. Jennifer took detailed notes, and I could see that she genuinely wanted to get this right. By the end of the meeting, I felt confident that the HOA would be moving in the right direction. As I drove home, my phone rang. It was a number I didn't recognize, but I answered anyway. Mr. Xenakis. This is Detective Sarah Thompson with the Phoenix Police Department. I was hoping you might have a few minutes to talk. My stomach dropped. About what? About your homeowners association. We received a complaint that needs to be investigated, and your name came up in the course of our inquiries. I pulled into a parking lot and put the car in park. What kind of complaint? I would prefer to discuss this in person. Would you be available to meet at the Sagaro Heights Community Center tomorrow morning at 10? Detective, I have no idea what this is about, but I need some context before I agree to meet. There was a pause on the other end. We are investigating allegations of financial impropriety within the HOA board. Several residents have filed complaints suggesting that funds may have been misappropriated. Your name came up because you recently had a confrontation with the board, and we were told you might have information relevant to our investigation. Financial impropriety. I don't know anything about the HOA's finances. Nevertheless, we would appreciate your cooperation. This is not an accusation against you, Mr. Xenakis. We are simply trying to gather information. I agreed to the meeting and hung up. Financial impropriety. That added a whole new dimension to the situation. If someone on the board had been stealing money, it would explain why they were so aggressive about maintaining control and so resistant to outside scrutiny. The next morning, I arrived at the community center to find 2 detectives waiting, along with Jennifer Morrison and 3 members of the HOA board. Patricia was notably absent. Detective Thompson was a woman in her 40s with short gray hair and a no-nonsense demeanor. She introduced herself and her partner, Detective Marcus Rodriguez, and then got straight to business. Thank you all for coming. We are investigating allegations that funds have been misappropriated from the Sagaro Heights HOA over the past 3 years. We have obtained financial records that show several irregularities, and we are trying to determine what happened and who is responsible. The brunette board member with glasses, whose name I learned was Diane Cooper, spoke up. We only became aware of the problem 2 weeks ago. After Mr. Xenakis raised questions about our bylaws, we decided to conduct a comprehensive review of our operations. That is when we noticed discrepancies in our accounts. Detective Rodriguez pulled out a laptop and turned it so we could all see the screen. Over the past 3 years, the HOA has collected approximately $200,000 in annual fees from homeowners. During that same period, documented expenses total approximately $400,000. That leaves a shortfall of $200,000. I whistled. That is a significant amount of money. It is. And it gets more interesting. The excess spending appears to have been authorized by the board president, Patricia Henderson, using a discretionary fund that was supposedly established for emergency maintenance and legal expenses. Deanne was shaking her head. We never voted to establish a discretionary fund. All major expenses are supposed to be approved by the full board. That is what your bylaws state, Detective Thompson agreed. But according to the financial records, Miss Henderson had signature authority on the HOA accounts and was making payments without board approval. One of the male board members, the heavyset guy from the hearing, whose name was Robert Chen, looked sick. What was the money used for? Detective Rodriguez clicked through several pages on the laptop. That is what we are trying to determine. Many of the payments were made to vendors and contractors, but when we contacted those businesses, several of them have no record of doing work for the HOA. We believe the payments may have been fraudulent. Jennifer Morrison leaned forward. Are you saying Patricia was writing checks to fake companies? We are saying that is one possibility we are investigating. We are also looking into whether she may have been receiving kickbacks from legitimate vendors in exchange for awarding contracts without competitive bidding. I thought back to my interactions with Patricia. Her aggressive enforcement of violations, her resistance to legal scrutiny, her anger when I challenged the board's authority. It all made sense now. She had been trying to maintain control because she was hiding something much bigger than just illegal bylaws. Detective, how does my situation relate to this investigation? According to several board members, you were the first person to seriously challenge Miss Henderson's authority. When you raised questions about the legality of the bylaws and threatened to involve the state, it apparently triggered a crisis within the board. They started asking questions they hadn't asked before, and that led to the discovery of the financial issues. So I inadvertently exposed embezzlement by arguing about a hedge. Detective Thompson smiled slightly. In essence, yes. Your challenge to the bylaws forced the board to consult with an attorney, and that attorney advised them to conduct a comprehensive review of their operations. That review uncovered the financial discrepancies. Robert Chen was staring at his hands. I should have been paying more attention. I'm on the board. It is my responsibility to know what is happening with the finances. Mr. Chen, unless you were personally involved in the fraud, you are not criminally liable. However, the board as a whole may face civil liability for failure to exercise appropriate oversight. Deanne looked panicked. We are going to be sued. Jennifer stepped in. Let's not get ahead of ourselves. Right now, the focus needs to be on cooperating with the investigation and determining the full extent of the problem. Once we have a clear picture, we can discuss liability issues. The detective spent the next 2 hours interviewing each board member separately. When it was my turn, I provided a detailed account of my interactions with Patricia, including her aggressive enforcement of violations and her resistance to legal oversight. I also mentioned what Jennifer had told me about the pattern of complaints filed against my property. Why do you think she was targeting you specifically? Detective Thompson asked. I don't know. I moved into the community about 2 years ago, right around the time the financial problems seemed to have started. Maybe she saw me as a threat for some reason. What do you do for a living, Mr. Xenakis? I am retired now, but I spent 20 years as a senior legislative analyst for the Arizona State Legislature. I worked primarily on housing and property law. Detective Thompson and Detective Rodriguez exchanged glances. Did Miss Henderson know about your background? Not initially. I told her during our first confrontation when she tried to cite violations against me. And how did she react? She got angry and defensive, but she also seemed worried, like she knew I could cause problems for her. Detective Rodriguez made a note. That fits with what we are seeing. If she was embezzling money, she would need to maintain tight control over the board and prevent outside scrutiny. Your background and expertise would have made you a significant threat to that control. After the interviews concluded, the detectives told us they would be executing a search warrant on Patricia's home and personal financial records. They also informed the board that the HOA's accounts would be frozen pending the investigation. What does that mean for homeowners? Deanne asked. We have bills to pay, maintenance to do. You will be able to access funds for essential services, but any discretionary spending will need to be approved by our office until we have completed our investigation. We need to ensure that no additional funds disappear. As everyone was leaving, Jennifer pulled me aside. This is going to get messy. The homeowners are going to demand answers, and there is going to be a lot of anger directed at the board. Even though most of the board didn't know what was happening. Doesn't matter. They were responsible for oversight, and they failed. Some homeowners will understand, but others will want blood. She was right. Over the next few days, word spread through the community about the investigation. My phone started ringing with calls from neighbors asking what I knew. A Facebook group for Saguaro Heights residents exploded with speculation and accusations. People were demanding emergency meetings, recalls, and lawsuits. I tried to stay out of it, but that proved impossible when I received a call from a reporter at the Arizona Republic asking for comment about my role in exposing the HOA fraud. I'm sorry, how did you get my name? One of the HOA board members mentioned that your challenge to the bylaws led to the discovery of the financial problems. We are doing a story on HOA oversight and accountability, and your case is a perfect example of why homeowners need to be vigilant. I gave the reporter a brief statement emphasizing that I had simply been trying to understand why I was being cited for violations, and that the financial issues were discovered by the board and their attorney, not by me. I didn't want to be painted as some kind of hero when all I had done was defend my property rights. The article came out 3 days later with the headline "Retired State Analyst Uncovers HOA Fraud Through Bylaw Challenge." It was more dramatic than I would have liked, but it was generally accurate. The article detailed Patricia's alleged embezzlement, the illegal bylaws, and the pattern of harassment against me. It also included comments from other residents who had experienced problems with the HOA but had been afraid to speak up. One resident, a woman named Gloria Martinez, was quoted saying that Patricia had threatened to fine her $5,000 for painting her front door without permission. Another resident, James Kowalski, said he had been cited for parking his work truck in his driveway, even though the bylaws allowed commercial vehicles under a certain size. The article ended with a statement from the Arizona Department of Real Estate saying they were reviewing complaints against Saguaro Heights HOA and would be conducting their own investigation into compliance issues. 2 weeks after the police investigation began, Patricia Henderson was arrested and charged with theft, fraud, and forgery. According to the indictment, she had stolen approximately $175,000 from the HOA over 3 years through a combination of fake invoices, inflated contractor bills, and direct transfers to personal accounts. The news hit the community like a bomb. Even people who had suspected financial problems were shocked by the scale of the theft. An emergency HOA meeting was called to discuss next steps. I attended the meeting, which was held in the community center and packed with angry residents. The remaining board members sat at the front table looking like they wanted to be anywhere else. Jennifer Morrison was there as legal counsel, and she started the meeting by explaining the situation. As you all know by now, Patricia Henderson has been arrested on charges related to the theft of HOA funds. The police investigation is ongoing, but preliminary findings suggest that approximately $175,000 was stolen over a 3-year period. The HOA's insurance policy covers theft by board members, so we are filing a claim that should recover most of the stolen funds. However, the process will take time. A man in the front row stood up. Why didn't the board know this was happening? Aren't you supposed to be watching the finances? Robert Chen stood up, his face red. You're right. We should have been more vigilant. Patricia handled most of the financial paperwork and we trusted her. That was a mistake, and we take responsibility for it. Taking responsibility doesn't get our money back. We pay thousands of dollars a year in HOA fees, and you people just let someone steal it. Jennifer tried to calm things down. I understand your anger, but right now we need to focus on moving forward. The board is implementing new financial controls, including quarterly audits and requiring dual signatures on all checks over $1,000. We are also establishing a finance committee that will provide independent oversight of the HOA's accounts. Another resident spoke up. What about the bylaws? I heard they're illegal. Jennifer nodded. We are in the process of revising the bylaws to ensure compliance with Arizona state law. Mr. Xenakis has been kind enough to provide guidance on what needs to change, and we expect to have revised bylaws ready for homeowner approval within 60 days. People started turning to look at me, and I realized I was going to have to say something. I stood up reluctantly. For those who don't know me, I'm Lucas Xenakis. I live at 4782 Desert Willow Drive. I worked for the Arizona State Legislature for 20 years, and I helped write many of the laws that govern HOAs in this state. When Patricia Henderson tried to cite me for violations, I challenged her because the bylaws she was trying to enforce were illegal. That challenge led to a broader review that uncovered the financial problems. So you're saying you saved the HOA? Someone called out. No. I'm saying I defended my property rights, and that happened to expose a bigger problem. The real credit goes to the board members who were willing to ask hard questions and bring in legal counsel when they realized something was wrong. An older woman in the back raised her hand. What happens to the money Patricia stole? Do we get it back? Jennifer answered. As I mentioned, we are filing an insurance claim. The policy should cover the theft, minus a $10,000 deductible. We are also working with the prosecutor's office to seek restitution as part of Patricia's sentence if she is convicted. What about the board? Are you all going to resign? Deanne Cooper stood up. We have discussed that option, and we understand if the community wants new leadership. However, we are in the middle of a crisis, and bringing in a completely new board right now could make things worse. We propose that we remain in our positions temporarily while establishing a transition committee to identify and train new board members. We would then hold a special election in 6 months. There was grumbling, but most people seemed to accept this as reasonable. The meeting continued for another hour, with residents asking questions about finances, legal issues, and future plans. By the end, the mood had shifted from anger to cautious cooperation. As people were leaving, several residents came up to thank me for standing up to Patricia. One of them was Gloria Martinez, the woman who had been threatened with a fine for painting her door. "Mr. Xenakis, I just want you to know that Patricia made my life hell for 2 years. Every time I did anything to my property, she was there with a violation notice. I was starting to think about selling my house just to get away from her. I'm sorry you went through that. No one should be harassed in their own home. When I heard you challenged her at the board meeting, I wished I had been brave enough to do the same thing. Thank you for standing up." I assured her that she would have done the same thing if she had known the law, but I could see the relief in her eyes. Patricia had been a bully, and her arrest had lifted a weight off a lot of people. Over the next few months, life in Sagaro Heights slowly returned to normal. The insurance company paid out the claim, recovering most of the stolen funds. The HOA's accounts were unfrozen, and essential maintenance that had been deferred was completed. Jennifer and I worked together to revise the bylaws, stripping out all the illegal provisions and replacing them with language that complied with state law. The revised bylaws were submitted to homeowners for approval, and they passed with an 87% yes vote. It was one of the highest participation rates the community had ever seen, which showed how much people cared about getting things right. Patricia's criminal case moved through the courts. She initially tried to fight the charges, claiming that she had been using the money for legitimate HOA expenses and that the board had approved her actions. But the evidence was overwhelming. The fake invoices, the personal account transfers, the missing records, it all pointed to deliberate theft. In the end, she accepted a plea bargain. She pleaded guilty to theft and fraud charges and was sentenced to 5 years in prison, with the possibility of parole after 3 years. She was also ordered to pay full restitution to the HOA, though nobody expected to actually collect that money. Most of what she had stolen was gone, spent on personal expenses and luxuries. The day of her sentencing, I went to the courthouse. I'm not sure why I felt compelled to be there, but I wanted to see the end of the story. Patricia looked diminished in her orange jumpsuit, standing before the judge as he read out her sentence. She didn't look at the gallery where several HOA residents were sitting, including me. When the judge asked if she wanted to make a statement, she stood and spoke in a voice so quiet I could barely hear her. "I know what I did was wrong. I convinced myself that I deserved the money because I was working so hard for the community, but that was a lie. I stole from my neighbors and I betrayed their trust. I'm sorry." It sounded rehearsed, probably something her lawyer had written for her, but there might have been genuine remorse in there somewhere. It was hard to tell. After the sentencing, I walked out of the courthouse into the bright Arizona sunshine. Detective Thompson was standing by her car, and she waved me over. "Mr. Xenakis, I wanted to thank you for your cooperation during the investigation. Your information about the bylaw violations and the pattern of harassment was helpful in establishing motive and consciousness of guilt. I'm glad I could help. Do you think she'll serve the full 5 years? Probably not. With good behavior, she'll likely be out in 3. But she'll be a convicted felon, and she'll have restitution hanging over her head for the rest of her life. That's not nothing." "No, it's not." Detective Thompson opened her car door, then paused. "You know, we see a lot of HOA disputes in our work. Most of them are petty stuff, neighbors arguing over fences and paint colors. But every once in a while, we find something like this, where someone in a position of power abuses that power for personal gain. The thing that strikes me is how easy it is for people like Patricia to get away with it for so long. It's because homeowners trust their board members. They assume that volunteers are acting in good faith, and most of the time they are. But it only takes one bad actor to cause tremendous damage. That's why what you did matters. You didn't just challenge some petty violations. You forced accountability where there wasn't any before. That's important. I appreciated her words, but I still didn't see myself as any kind of hero. I had just been defending my property rights and using the knowledge I had gained from years of working on housing law. If anything, the whole situation had shown me how important it was for homeowners to understand their rights and for HOAs to operate transparently and within the law. 6 months after Patricia's arrest, Xenakis Heights held the special election for new board members. There was a huge turnout with 12 people running for 5 positions. I was asked to run, but I politely declined. I had spent enough time dealing with bureaucracy and politics during my career. Retirement was supposed to be about relaxing and enjoying life, not attending endless board meetings. The new board was a good mix of people with different backgrounds and perspectives. They immediately implemented the new financial controls and oversight procedures that Jennifer had recommended. They also established a grievance process for homeowners who felt they were being treated unfairly, with an independent mediator available to resolve disputes before they escalated. The community felt different after everything that had happened. People were more engaged, more willing to ask questions and hold leadership accountable. The Facebook group that had been filled with speculation and anger during the investigation became a useful forum for community discussion and problem solving. As for me, I finally got to enjoy my retirement. My hedge remained at 44 inches, my mailbox stayed Benjamin Moore black, my fountain burbled happily in the front yard, and I left my garage door open whenever I felt like it. Nobody said a word. One Saturday morning, about a year after the whole ordeal began, I was out front watering my plants when a car pulled up and a young couple got out. They looked at the house across the street, which had a for sale sign in the yard, and then walked over to me. "Excuse me, do you live in this neighborhood?" the woman asked. "I do, for about 3 years now. We're thinking about buying that house. Can you tell us what it's like living here? How's the HOA?" I smiled. "Well, that's an interesting question. Let me tell you a story." I gave them the condensed version, the illegal bylaws, the confrontation with Patricia, the discovery of the embezzlement, and the community's efforts to rebuild and reform. I watched their expressions go from interest to shock to concern and finally to cautious optimism. "So after all that," the man said, "would you still recommend living here?" "Absolutely. Every community has problems, but what matters is how they deal with those problems. This community could have fallen apart after what happened. Instead, people came together, held leadership accountable, and made real changes. The HOA now operates according to the law with proper oversight and transparency. That's about as good as it gets." The couple thanked me for my honesty and went to look at the house. A few weeks later, I saw moving trucks pull up across the street. The couple had bought the house. They waved as they unloaded furniture, and I waved back. That evening, I sat on my back patio watching the sun set over the desert. My phone buzzed with a text from Jennifer Morrison. She was working with another HOA in Scottsdale that had similar problems to what Xenakis Heights had experienced, and she wanted my input on their bylaws. I told her I would take a look. It seemed that even in retirement, I couldn't completely escape the world of HOA regulations and property law. But that was okay. After everything that had happened, I understood how important this work was. HOAs affected millions of people across the country, and when they operated outside the law or allowed corruption to flourish, real people got hurt. I had spent my career writing laws designed to protect homeowners and ensure that HOAs operated fairly and transparently. Now, I had seen firsthand what happened when those laws were ignored and what it took to restore accountability. It had been frustrating and stressful at times, but it had also been oddly satisfying to see the system work the way it was supposed to. My phone buzzed again. This time it was from Diane Cooper, one of the former board members who had stayed involved in the community. She was letting me know that the HOA had received an award from the Arizona Department of Real Estate for excellence in governance and transparency. It was recognition of how far the community had come in just 1 year. I texted back my congratulations and put my phone away. The sun had fully set now, and the stars were coming out. In the distance, I could hear the sounds of the neighborhood kids playing, dogs barking, the general hum of people living their lives. It was peaceful. My garage door was open because I had been organizing tools earlier and hadn't gotten around to closing it. According to the old bylaws, that would have been a violation. According to Patricia Henderson, it would have been grounds for a $500 fine. But according to the law I had helped write, it was nobody's business but my own. I smiled to myself and went inside, leaving the garage door open just because I could. Sometimes the smallest acts of defiance were the most satisfying. And sometimes, standing up for your rights led to changes much bigger than you ever expected. The hedge was still 2 inches too tall. The mailbox was still the wrong shade of black by the old standards. The fountain still burbled without official approval according to the old timeline. And my garage door stayed open as long as I wanted. But now, all of that was perfectly legal, perfectly acceptable, and perfectly fine. Because at the end of the day, I hadn't just defended my property rights. I had helped an entire community rediscover what it meant to have an HOA that served homeowners, rather than the other way around. Patricia Henderson had tried to use regulations to control and intimidate people, never realizing that the person she was targeting had literally written those regulations for the state. It was ironic, really. She had tried to cite laws at me that I had drafted. She had tried to enforce bylaws that violated statutes I had carefully crafted to prevent exactly that kind of overreach. And in doing so, she had brought down not just her own illegal reign, but had exposed her criminal conduct to the world. The story could have ended in a lot of different ways. I could have just paid the fines and moved on. I could have sold my house and left the community. I could have filed a lawsuit and made the whole thing even more contentious. But instead, I had used knowledge and patience to achieve a better outcome for everyone involved. Well, everyone except Patricia. She was sitting in a prison cell, contemplating the consequences of stealing from her neighbors and wielding petty power like a weapon. I didn't take pleasure in her downfall, but I didn't feel sympathy either. She had made her choices, and now she was living with the results. As for the community of Saguaro Heights, it would continue to evolve and grow. New families would move in, like the couple across the street. The HOA would face new challenges and have to adapt to changing circumstances. But now, they had a foundation of legal compliance and transparent governance that would serve them well. And me. I would continue my retirement, hopefully with fewer dramatic confrontations with HOA board members. I would consult occasionally on HOA law when asked, sharing the knowledge I had gained over 2 decades of legislative work. I would water my hedge and maintain my fountain and park in my garage with the door open. Most importantly, I would remember that standing up for your rights, even in small matters, can have ripple effects you never anticipate. A 2-inch hedge had led to the exposure of $175,000 in theft. A mailbox color dispute had triggered reforms that would protect homeowners for years to come. An open garage door had helped bring down a corrupt board president. The law is meant to protect people, not to be weaponized against them. That was the principle I had tried to uphold throughout my career, and it was the principle that had guided me through this entire ordeal. Patricia Henderson had forgotten that principle, or perhaps had never understood it in the first place. She had seen the law as a tool for control rather than a framework for justice. In the end, justice had prevailed. Not perfectly and not without cost, but it had prevailed nonetheless. The stolen money was recovered. The illegal bylaws were corrected. The community was stronger and more engaged. And one retired legislative analyst had proven that knowledge truly is power, especially when it comes to HOA regulations you wrote yourself. I went to bed that night feeling content. Tomorrow would bring new challenges and new opportunities. Maybe the HOA would discover another issue that needed addressing. Maybe another community would reach out for help with their bylaws. Maybe I would just spend the day reading a book with my garage door open and my hedge gloriously, legally, 2 inches too tall. Whatever tomorrow brought, I was ready for it. Because I had learned something important through this whole experience. Retirement doesn't mean stopping work that matters. It just means choosing which work matters to you. And helping communities understand and apply the laws that govern their homes that mattered to me. The hedge could stay at 44 inches. The mailbox would remain its current shade of black. The fountain would continue to burble. And I would continue to be living proof that when you challenge authority, you better know what you're talking about. Especially when you're the person who wrote the rules in the first place.